I have my family here with me today. You sit in a hospital and they tell you that you have cancer and that it's an aggressive cancer. And even if
Before this sentencing even begins, you need to understand the emotional collision happening inside this courtroom. This is not just a drug trafficking case. This is a woman standing before the same judge who has sentenced her before, multiple times, now claiming she has finally reached rock bottom. She's facing aggressive cancer, chemotherapy, possible recurrence, and a child undergoing surgery. All while the court weighs whether compassion can coexist with accountability. On the other side of that scale, a long criminal history, prior prison sentences, drug trafficking convictions, years of failed supervision, and a justice system that has already tried treatment, probation, judicial release, and watched it all fail. What you're about to hear is not a judge without empathy. It's a judge forced to decide whether tragedy excuses crime, or whether responsibility remains, no matter how painful the circumstances become. So here's the question to keep in mind as this unfolds. When someone truly changes at their lowest point, how late is too late for mercy?
I have my family here with me today. You sit in a hospital and they tell you that you have cancer and that it's an aggressive cancer. And even if when I go through my cancer treatments and my chemo, that the likelihood of it coming back.
5 CR
is very, very
14958. Present before the court is Ms. Clark, represented by Mr. Moss, and we have Mr. View from the prosecutor's office, Officer Bridgman from probation. We are here today for sentencing. Other than what was contained in the motion for continuance, Mr. Moss, any reason not to go forward with sentence today?
No, Your Honor.
All right, as a preliminary matter, the court has provided Ms. Clark, through her attorney, with two documents. One is a notification on indefinite term, Reagan Tokes. Ms. Clark, you're going to be receiving both a minimum and a maximum term. It's what we call a Reagan Tokes
This
sentence.
is an important moment legally, even if it sounds procedural. When the judge explains a Reagan Tokes sentence, he's outlining something far more serious than a standard prison term. This isn't a fixed release date. It's an indefinite sentence, meaning the defendant could be released at the minimum, or held until the maximum if the Department of Corrections determines she's not ready. That distinction matters, because it shifts power away from the courtroom and into the prison system. Behavior, rehabilitation, and compliance inside prison now directly affect how long she stays incarcerated. The judge is making sure Ms. Clark fully understands that reality before moving forward. This also signals the seriousness of what's coming. Courts don't issue Reagan Tokes notifications casually. They're reserved for high-level felonies where public safety and long-term risk are central concerns. So ask yourself, does indefinite sentencing create accountability? Or does it add uncertainty to an already harsh
What we call a
punishment?
Reagan Tokes sentence. It's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections may, under certain circumstances, keep you up to the maximum penalty. You have something there called a notification Reagan Tokes. I'm going to attach this to the sentencing entry as Exhibit 1. Do you want me to read this to you, or are you satisfied that you understand and have been notified about the Reagan Tokes
I
sentence?
understand.
Next, we have post-release control. You're going to be subject to a mandatory period of post-release control of anywhere from 2 to 5 years. Same notification. Do you want me to read this to you, or are you satisfied that you understand? All right. Mr. View, on behalf of the state.
Your Honor, consistent with the plea agreement with the defense, as the court's aware, Ms. Clark has a prior history of trafficking, prior prison sentences imposed due to her drug trafficking history. And based upon that, I think in terms of the 4 cases, the state's recommendation is to count 3 that the court impose a minimum definite mandatory term of 8 years to a maximum indefinite term of 12 years, and that she received
The prosecutor doesn't waste time here.
1, 5,
He
and
anchors
7.
his recommendation firmly in history, not sympathy. Prior trafficking, prior prison sentences, a pattern of behavior the court has already addressed more than once. That's why the state is asking for 8 to 12 years, even with concurrent counts. This isn't about one bad stretch. It's about recidivism. And from the prosecution's perspective, repeated trafficking offenses signal someone who returned to the same conduct despite past consequences. Courts take that seriously because repeat behavior weakens arguments for leniency. What's notable is how cleanly the prosecutor stays within the plea agreement. He's not dramatizing. He's not attacking. He's simply saying, based on what she's done before, this is the appropriate range. And here's the engagement question. At what point does personal hardship stop outweighing a repeated criminal pattern?
5 and 7.
Mr. Moss?
Your Honor, we disagree with that sentencing recommendation. I've read for the first time here in the PSI, and I understand this. My client, this isn't something people like to talk about, her history of sexual abuse and trauma, which corroborates what I'm arguing is this is a drug addict who basically is on the spoke. There's a hub of drug trafficking, and then there are spokes, the people out in the street who do the transfers. Any funds obtained from that, she used methamphetamine. She's a drug addict. And I looked through her PSI, and this isn't finding fault with anyone else, but she kind of slipped through the cracks in terms of rehabilitation. She'd be off the street during her time, but between the child sexual abuse and other trauma in her life, apparently she has a diagnosis of bipolar disorder, major depressive order, PTSD. So that you have a strong case of self-medication. I've seen many cases like this. When I was in New Mexico, I represented many females in similar situations. She was employed, and she was released on bond and didn't have any dirty UAs, which is actually not par for the course. Usually they have all kinds of problems once they get out, but the one thread that ran through it, in my experience doing this many years, was sexual abuse. I think that she's proven, first of all, that's a mitigating factor. Whenever someone engages in criminal activity as a result of trauma or some type of mental illness, it's different than if they're just profiting off other people's addictions. In this case, Your Honor, I think the state's action.
This is where the defense shifts the entire emotional tone of the hearing. Trauma, sexual abuse, bipolar disorder, PTSD, major depression. The argument is clear. Miss Clark isn't a kingpin. She's a spoke in a larger drug operation, driven by addiction and untreated mental illness. Legally, this is mitigation, not excuse. The defense is asking the court to see why the behavior happened, not deny that it did. And the judge is listening. You can hear that. The emphasis on clean drug screens while on bond and stable employment is meant to show capability for compliance when structure exists. But there's tension here. Trauma explains behavior. It doesn't erase harm. The court must decide whether untreated illness reduces culpability, or simply explains why rehabilitation has repeatedly failed. So here's the hard question. Should trauma lessen punishment, or make treatment mandatory within incarceration?
State's actions help support the fact that she's not dangerous. As I pointed out in my motion, these are controlled buys in which the state was involved in each one. And each time she was sent home, each time they set something else up again, sent her home again. If there was any threat that she had firearms or was selling contaminated drugs or trying to get people to overdose and die, she would have been arrested after the first sale. So I don't think the consecutive, well, I guess they're just asking for 8 years on one sentence, which makes it easier legally. But I would contend that in terms of protecting the public, a much lower sentence is needed. In fact, I think she's proven that through her actions in employment and staying off drugs, that she's not a danger at all, as long as she's supervised. The second half of this is what we've talked about prior to court, and I thank the court for being willing to consider staying the execution of the sentence, is this person is at rock bottom in life. I don't know how more of a dire situation she could be in and still be present with us today. She's facing a life-threatening illness, which is going to require a lot of very uncomfortable treatments to even survive. So this is something she has to deal with, and she understands. She's always taken responsibility for her actions between her and I, never once considered trying to blame anyone else or floating some type of defense. She's been a very pleasant client to represent. She also informs me, and again, this is a personal thing, her 8-year-old daughter's in Cincinnati Children's Hospital this morning. They're going to be going right there after this hearing, if the court allows it, to, she's in surgery for something involving her digestive system. I'm having a hard time wrapping my head around
This
what
is the emotional core of the defense's argument. Cancer, chemotherapy, high recurrence risk, an 8-year-old child undergoing surgery the same day. These aren't tactics, they're realities, and the judge does not dismiss them. But listen carefully to how this is framed. The defense isn't asking for forgiveness. They're asking for time, a stay, a delay, a chance to survive treatment before prison begins. This is where sentencing stops being theoretical and becomes profoundly human. Still, courts must balance compassion with consistency. If illness alone prevented incarceration, sentencing would become uneven. Judges know this. That's why every word here matters. Audience question: should terminal or life-threatening illness delay punishment, or should the sentence stand regardless?
Hard time wrapping my head around what my client is going through. Your Honor, I would ask for I know the court's already sentenced her twice. 3 times, but for drug trafficking, twice. And she's let you down. But the PSI is recommending mental health treatment, residential services for mental health and substance abuse. I think that this should have happened sooner. It's possible we wouldn't be sitting here today. But I'd ask for a sentence far below that, consistent with the other sentences the court gave, because she's proven through her actions she's not a danger. And she's much less of a person physically than she was when she committed these offenses. She doesn't have the physical capacity to engage in more criminal conduct. And there's a lot of good in this person. There's an explanation now for why she was doing what she was, and her role in the offense was more of the spoke than the hub. And I understand this more now. So I would ask for a much lower sentence.
What do you want to tell me, Ms. Clark?
I just want to apologize to the courts. I've had a life-changing experience going through life, knowing that I might not have a life to live much longer, and I realized that I've messed up my life, my whole life, and I've hurt the community, and, I look at life a lot differently right now, and I'm really trying to do better. Like, I've gotten married, I'm in my kids' life, I have an awesome relationship with my kids now. I've never had that before. I have my family here with me today. Knowing the fact that you sit in a hospital and they tell you that you have cancer and that it's an aggressive cancer, and even if when I go through my cancer treatments and my chemo, that the likelihood of it coming back is very, very high. I'm scared. All I want is my family now. I don't talk to anybody that I used to have contact with. I've completely changed my life. I've moved. I am now living with my mother. I'm not in Warren County anymore. I've removed myself from the people, places, and things that I'm supposed to. I'm just right now just concentrating on my health and living every day that I have to be with my family and be positive and try to get myself together.
When the judge says, "You and I have known each other a long time," the courtroom dynamic changes instantly. This is no longer a stranger evaluating a file. This is a judge recounting years of attempts: probation, prison, supervision, judicial release, all exhausted. And that's why this line hits hardest. This is just an impunishment case. The judge isn't being cruel. He's being honest. He's acknowledging empathy, but rejecting the idea that the system failed her. In his view, the system tried, repeatedly. This moment reframes everything. The judge accepts that fear and illness can be transformative, but he also recognizes that past life-changing moments didn't stop the cycle before. So here's the question: how many chances should the justice system give before accountability becomes unavoidable?
Ms. Clark, you and I have known each other for a long time. Sent you to prison for the first time back in 2013, back in the days when we used to still cook meth, and people would go around the community collecting stuff. It's been the same story, Ms. Clark, pretty much the entire time, and I don't think it is either fair or accurate for it to be represented that we have not done everything that we could do in our power to try to put you back on track. You were on probation with me for a while. We tried prison, we tried judicial release, we tried supervision, we tried everything that we could do.
And I'll be real honest with you, Honor. I wasn't ready then. I didn't care about my life at that point in time. I really didn't. I didn't care about shit, you know? And I'll be honest with you, not long ago, I still didn't care. But when my everything got taken from me, like, and I got told that I could lose my life, that I could lose my leg, like, my thinking of stuff it's been, it scares me. It scares me to lose my life.
I don't want to minimize that, Ms. Clark, because I get what a life-changing experience that could be. And, I mean, you know, I hope things come out okay with the surgery in your daughter. I mean, you were on supervision with me when you had your daughter. I mean,
Yes.
I have a picture of your daughter right here in my notes from when she was born. So, I mean, we've been through life-changing experiences also before. This is just a punishment case, Ms. Clark. That's all it is. What I'm going to do is I'm going to sentence you to 3 to 4.5 years on each of the felony twos. They're going to be served concurrently with one another. So you have a 3-year mandatory prison term. It's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections can, under certain circumstances, keep you up to the maximum penalty. I'm going to sentence you to 36 months in prison on the F3. I'm going to order that these be served consecutively, one after another, for a total of
The sentence is
6
complex and severe. 6 years total, 3 mandatory years on felony 2s, followed by consecutive time on a felony 3. Indefinite structure, post-release control, supervision, potential return to prison for violations. This is not symbolic punishment. This is incapacitation paired with oversight. The judge also removes financial penalties due to indigency, showing fairness even while imposing incarceration. And critically, he stays the sentence temporarily, acknowledging the medical crisis without abandoning accountability. This is judicial balancing at its most difficult: punishment, mercy, public safety, and humanity. all in one ruling. So pause here and consider. Does this sentence strike the right balance, or does it lean
Actively
too
one
far in
after
one
another
direction?
for a total of 6 years in prison. The F2s, the mandatory time will be served first, so you have to get that mandatory time out of the way, and then you will begin serving the consecutive sentence for the F3. We have an indigency affidavit, I assume, somewhere, Mr. Moss, right? Mr. Moss, we have a,
That's what I didn't get done with because I was out there talking.
okay, where is it these days? Where, we keep moving it around? I do find that you're indigent for the purposes of fines and costs. There will be no financial sanction in the case. You're also subject to the post-release control that we talked about a couple of minutes ago. It means the adult parole authority is going to supervise you, and if you violate the terms of that supervision, then you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. I'm going to stay the imposition of this sentence, and I'm going to set this for a status conference sometime in June. I'm not going to continue to put this off indefinitely, Ms. Clark, but I do realize that you are probably at a critical point in your treatment. So you're going to continue to remain on supervision until that time with pretrial. Anything else? Anything I forgot?
Your Honor, maybe I misheard you, but the indefinite term on counts 3, 5, and 7 is 4.5. It's
3 to 4.5? Is that not what I said?
That's what I was saying. I wasn't sure if I heard you. I thought you said 3 to 4. I just wanted to make sure.
I'm sorry, it's 3 to 4.5.
Yeah.
Because it's 1/2 of the,
Yes.
it's 50% of the mandatory term. All right. Anything else? All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Mr. Moss, why don't you go ahead and give us a temporary bill in the case, but I do want to keep you on for the status conference. I don't want you to have to wait 5 months to bill for this case, though. So let's go ahead and get a status conference sometime in June.
Okay, thank you, Judge.
Okay? All right.
The
Good luck to you,
sentence
Ms.
is
Clark.
complex and severe. 6 years total, 3 mandatory years on felony 2s, followed by consecutive time on a felony 3. Indefinite structure, post-release control, supervision, potential return to prison for violations. This is not symbolic punishment. This is incapacitation paired with oversight. The judge also removes financial penalties due to indigency, showing fairness even while imposing incarceration. And critically, he stays the sentence temporarily, acknowledging the medical crisis without abandoning accountability. This is judicial balancing at its most difficult. Punishment, mercy, public safety, and humanity, all in one ruling. So pause here and consider. Does this sentence strike the right balance, or does it lean too far in one direction?